Thank you. Good morning, everybody. Thanks for that introductory presentation about me. First of all, let me thank the Vice Chancellor as well as the Dean Faculty of Law for inviting me to chair this very important technical session. I welcome all of you for 2 hours of good deliberation. I have just been given the instructions. There are five topics to be delivered. I feel they are quite interactive and there's a lot of insight into the topics that have been given to the presenters. Every presenter has about 10 minutes, and I was told that there's a panel of judges who will select the best presenter at the end of the deliberation. Let me not take much time and introduce the first presenter. That is MRIK Munasinghe, who will deliver the topic on exploring the child custody laws in Sri Lanka, balancing parental rights and best interests. I believe it's a very pertinent permanent topic. Kumarasinghe is an undergraduate of Faculty of Law, and she is also pursuing a diploma in professional human resources management. And she also holds an advanced certificate in human resources management from the Chartered Institute of Personnel Management. And I was told that she's an enthusiastic researcher in law of persons, a very important topic, which I believe in the legal field, very few people are interested in this particular topic. Let me introduce Kumarasinghe, and the floor is yours. And you will have 10 minutes. And we will always see that we will have to stick to the time. At the end of the 8th minute, she will be in the bell. At the end of the 10th minute, we will also indicate the time. The floor is yours.
The Chair, distinguished guests and participants, I, MRIK Munasinghe, will be doing this presentation here today. My research topic is Exploring the Child Custody Laws in Sri Lanka, Balancing Parental Rights and the Best Interest, which focuses on the complex relationship between parental rights and the best interest of the children within Sri Lankan custody legislation. In Sri Lanka, when you are under 18, you are considered as a minor and your parents have authority over you. Family is highly important in Sri Lankan culture, so divorce, especially when children are involved, can be very difficult. When it comes to child custody under Sri Lankan law, there are two main situations. First, when a couple lives separately but haven't divorced yet, and the second, when they have already divorced. In the past, South African law favored fathers in custody cases, but that has changed over time. Now, the focus is on what's best for the child, known as the welfare of minors, to avoid neglecting their well-being. Sri Lankan courts today prioritize the best interest of the child when deciding custody. However, figuring out what's best for the child can be tricky because it depends on each unique situation. It is an essential topic to ensure children's well-being when parents go through a divorce. In the research study, a qualitative approach was employed to investigate child custody within the Sri Lankan legal system. The study incorporated an analysis of local laws and pertinent court cases, assisting an understanding of how child custody matters are managed. Primary sources of information included contemporary legal status, international courts ruling, and reputable textbooks. Additionally, secondary sources as articles, websites are consulted to enhance the research finding. In next slide, regarding the legal framework governing the child custody in Sri Lanka. Historically, under Roman Dutch law, fathers held sole authority as natural guardians due to mothers lacking independent legal status. Two key principles emerged. Father had a preferred right to custody in married couples, and in case of divorce, the innocent spouse gained custody. Back then, the court decided what it thought was right without thinking much about what is best for the child. However, during divorce, Sri Lankan courts focus on child's best interest with decision based on present facts and evidence. Sri Lanka lacks a standardized measure to guide the discussion, unlike some other jurisdictions. Interestingly, the wishes of all the kids matters, but only up to certain age because of English law. While sole custody with non-custodian parent access is common, joint custody remains unexplored. The primary principle, both in Sri Lankan draft constitution and international commitment, is to prioritize the child's best interest. In next slide, moving into the parents' rights in child custody. Historically, fathers enjoyed preferred rights in custody matters as fathers were considered as the natural guardian. However, over time, the focus has shifted towards the welfare of the child. Sri Lankan courts have increasingly favoured mothers as custodian when they are deemed qualified, marking a departure from earlier ruling. The reflect and acknowledgement of the importance of the mother's role, particularly in preventing maternal deprivation and its potential long-term effects on children. In case of separation or divorce, custody arrangement can be determined by mutual agreement or through the family law courts. Notably, under English law, fathers could challenge custody decision through habeas corpus petition. However, it is vital for family law courts to retain primary authority to safeguard the child's welfare. In terms of parental rights, both parents have the power to name guardians for their children's property, manage their assets, invest their money, and decide on the religious upbringing. Nevertheless, the gender equality persists in parental right, with father often holding superior rights. In the next slide, examine the profound concept of the best interest of the child. In the context, International Convention and Sri Lankan legal tradition. The United Nations Convention on the Rights of the Child, Article 3, places paramount importance on considering the child's best interest when making decisions and effect them, and include child's rights to live with their parents as long as it doesn't harm them and to maintain contact with both parents. Sri Lanka custody laws were shaped by the colonial influence of English and Roman Dutch law tradition. Initially, father had more rights in custody matters. However, a significant change occurred in cases like Calitz versus Calitz in 1939, where the courts intervened to protect the child's well-being as the top priority. In recent years, there has been a shift towards favouring mothers in custody decisions, emphasizing the child's best interest as seen in the Fernando versus Fernando case in 1956. The change applies when the parent separates or divorces with the focus straight on what is best for the child. The courts also considers the child's age when listening to their preference, but there are not clear rules for that. When third parties seek custody, the court still puts the child well-being above all else, and normally biological parents are preferred unless they are proven fit. The bottom line here is always the child's welfare. In the next slide, address the crucial need for the delicate balance between parental rights and the best interest of the child in the jurisdiction of the family. Sri Lanka, like many nations, deal with this complex issue. In essence, Sri Lanka aims to harmonize the rights of parents with the vital concerns of the child's welfare. The courts recognize that parental rights, especially fathers, can prevail if they are strongly argued and do not conflict with the child's best interest. Even when one parent is granted custody, non-custodial parents are typically entitled to reasonable access to their children. This supports the importance of parental authority while ensuring the child's well-being. The mother is usually the child's sole guardian, but if vital reason exists, the biological father may be granted custody while maintaining contact with the child. Religious and conscience right as per Sri Lankan constitution sometimes clash with the parental rights in regulating religious upbringing. The child's age and majority play a crucial role resolving this tension. Some countries promote shared parenting or joint custody, prioritizing the child's healthy relationship with both parents. Sri Lanka, while not explicitly approving shared parenting, attempt to balance a child's best interest with parental rights. In the next slide, we can see some key factors determining the best interest of the child in custody arrangement. Several key factors come into play. The age of the child is a crucial consideration, as it affects their ability to comprehend and express their preferences. If the child is mature enough, their desires should be taken into account. Additionally, the emotional stability of the child is evaluated to ensure they can cope up with the custody changes. Assessing the fitness of both parents, both physically and mentally, is essential to provide a stable and supportive environment. The quality of the child relationship with both parents and extended family members is also considered. In the next slide, through strengthened Sri Lankan child custody law, we recommend to maintain a balanced approach. One recommendation is to introduce family advocacy or court welfare officer similar to European jurisdiction. Moreover, Sri Lanka should address issues like equal rights granted to parents regarding custody. Both parents should have equal rights over children even in custody cases, and this should be legalized. And the next recommendation, centralizing custody matters in district courts and clarifying the circumstances for requesting a higher court's intervention. This also can help to avoid misunderstandings. Lastly, we suggest promoting shared parenting engagement as seen in South Africa when it is the child's best interest. In the next slide, here are some notable case studies within Sri Lankan legal system which shows the significant shift towards prioritizing the child's welfare and the best interest over parental preferences is evident. In the case of Fernando versus Fernando, the court approach evolved to favor the mother's custodial rights and the child's well-being, challenging the father's preference. Similarly, in the case of Veregoda versus Veregoda, and emphasized the child welfare above parental rights, disregarding the father's position. Finally, the case of Custom versus Custom shows that introduction of shared custody provision through mutual agreement, reflecting the delicate balance struck between parental rights and the best interest of the child. As conclusion, as per striking the delicate balance between parental rights and the best interest of the child is the universal challenge in child custody law. So globally, jurisdiction emphasized this principle and Sri Lanka drew a valuable insight while customizing its two unique contests. Above all, the welfare of the children is mandated by the nation's legislation, stands as the central concern of the discussion. Thank you so much.
I would say there was a lot of wisdom and there was a lot of insight into literally on a slide. In fact, you touched upon a lot of things, divorce law and also the custodial law, and you didn't tell only about the best interest of the child. You spoke about the balancing of the parents' rights as well as the best interest of the child. And what really interested me was the joint custody that you spoke about, and the property, how it evolves after the legal battle starts. And you spoke also about the history, how the Roman Dutch law comes in. So congratulations for that wonderful presentation, and I wish you well. Our second presenter for today is going to be MRIK Munasinghe. She is going to talk on living in adultery as a ground for losing the opportunity to claim maintenance. very interesting topic. A critical appraisal of the Sri Lankan judicial standpoint. May we welcome MRIK Munasinghe, who is a senior lecturer at the Department of International Law, Faculty of Law of this General Sir John Judicial Academy. She holds an LLM in International Trade Law from the University of Wales, United Kingdom, and also a Master's in Human Rights and Democratization, a postgraduate diploma in Human Rights, and an LLB from University of Colombo as well. She's an attorney at law. Ms. Kumarasinghe, the floor is yours. You will have 10 minutes.
Good morning, Honorable Chair and my colleagues and our students. Now this is going to be a little strictly focused on maintenance law, and I would say this is particularly based on a single section of the statute. Now my topic would be living in adultery as a ground for losing the opportunity to claim maintenance, a critical appraisal of the Sri Lankan judicial standpoint. Right, now coming into Roman Dutch law, now it's a kind of a reciprocal duty of maintenance and duty to support among and between the spouses, and also according to Wood, it says lifelong association directs that the needy wife shall be maintained by the husband and the proper husband by the wife itself. And here this would leads to rise to interesting questions where it has to be clarified as to what extent does the wife financial status matters to obtain maintenance from the husband. And the second one would be how to recognize wife's reciprocal duty towards the maintenance of the husband. Now that 2 points were generated via the literature of Dr. Parental. So therefore, now here the particular sections of this maintenance statute, section number 2, the proviso, it says there are 2 exemptions where you would lose the opportunity for maintenance, where the applicant spouse is living in adultery or both the spouses are living separately by mutual consent. And it is evident that there is no any consistencies maintained by the Sri Lankan judiciary in constructing the phrase in living in adultery as appropriate for maintenance cases. Now this has been particularly defined in terms of the divorce cases, but in the maintenance jurisprudence it has not been properly placed. And when it comes to the previous maintenance statute, which was in 1889 maintenance ordinance, it has used the similar terms of living in adultery on few occasions, whereas in section 3 it says if such person offers to maintain his wife on the conditions of her living with him, and magistrate may consider on any grounds of refusal stated by her and may make an order notwithstanding such an offer. And also, no wife shall be entitled to receive maintenance allowed if she is living in adultery under section 4 of the same ordinance. And then even a granted allowance shall be ordered, and it could be cancelled upon if any proof of living in adultery under section 5. Right. Now therefore, this study is going to uncover the question of the efficacy of the domestic judiciary in dealing with the term of the living in adultery in relation to the previous act and the present act. Now the objective of this study is to extend to understand to what extent the living in adultery phrase has been defined under this particular prescribed sections. And this question will be unpacked on applying 2 research methodologies, that is to black letter approach and the comparative legal research methodology. And the black letter approach has been employed to analyze the statutory provisions, and comparative legal research methodology has been applied to analyze and employ appropriate understanding of the construction of the terms in par with to the scope of the study. And then we need to understand how to define this legal definition, and a general definition has been provided to adultery. Now in my study I have screwed it into three aspects, that is general and legal explanation of the terminology of the adultery, statutory definitions, and now emphasis towards the particular term called adultery, and the judicial interpretations. Now, before understanding living with adultery, you have to have an understanding what an adultery means. Now, I would give a few examples where the foot explains adultery as a violation of the court of another. That is to say, the definition of the mother of another household may be between married man and unmarried woman, and an unmarried man and a married woman. And in par with the statutory definitions, I would quote the Penal Code of India, section 497. It defines the adultery. And then coming into judicial interpretations, there are several judicial interpretations, and this had been par with this Indian jurisprudence and the British jurisprudence. Now, coming into this understanding and distinguishing the living in adultery phrase, which particularly focused on this maintenance claim. Now, to understand, there are two ways that it has to be understood. The first level is the general understanding, that is the level and the duration of the adulteral behaviors, and shall be determined based on the circumstantial evidence of the relevant context. That is case number 1. The case number 2 has to be, now Indian jurisprudence has been particularly qualified in what and when this, the living in adultery could be qualified as two types of. That is, what is outright adulterous conducted where the wives live in the semi-permanent union with a man who commits adultery. The second one is single or occasional lapses of virgin, and adultery committed prior to the marriage shall not be affected in claiming maintenance. Now, in such a background, now we are going to understand our context, and this is going to be understood in two types of. The first two, how to interpret the terminology in living adultery, and the level of burden of proof. And when it comes to the terminology, now, coming into the two statutes, they have not been particularly interpreted, neither adultery or living adultery, and we have to generate the particular interpretation throughout the judicial determinations. And the level of proof or the burden of proof is also having different scales where in par with the general applications of this maintenance claims. Now, coming into this key maintenance aspects, which is going to be derived of living in adultery context, there are few cases based on the modern or the present case, under present statute, there are two key cases. And under the previous ordinance, we have a chain of case where always it has been referred by the judiciary continuously. And this, the cases under the existing legislation to refer the same context in understanding living and adultery phrase, and how to emphasize towards the proof of adultery. And coming into previous ordinance, it says that section 3, 4 and 5 are being used with the term of living in adultery, which shall be considered the construction of the same as referred to few significant matters relating to maintenance. It was established by domestic judicial decisions that living in adultery shall be considered as a several occasions of committing adultery by the applicant and or committing adultery at the time of maintenance application. The term had demanded the construction of the continuation of adulterous conduct. Now, this has been and outspoken and pronounced in few these instances where Justice Javadana in the Simonona case, it was cited that wife is entitled to maintain, although she had left the husband due to his adulterous behavior and lived with adultery sometimes back, and on the basis of that respondent has failed to prove that applicant is at the present living in adultery in the status. Now, likewise, now when it comes to the modern aspect, the burden of proof is going to be crucial of the present statute. The same cases have been referred, and but it has been in Chandrasiri versus Ravindi Kumara, it was the most recent judicial determination on this matter, which classified the judicial precedent of the divided and referred cases mentioned in this study, and both this under previous ordinance and the existing statute, which established the fact that the judicial opinions was constituted at or about the time context in the case of proof of adultery. Proximity in the time between the living in adultery and filling a maintenance application is a question of fact, and such case shall be treated independently. And therefore, I have few conclusions being made, having referred all the cases. Now here, under this, no specific statutory interpretation is provided to define either adultery or living in adultery in Sri Lanka. Therefore, it is been recommended to phrase shall be subjected to interpretation of the judiciary as per the factual circumstances. The second instance, adultery shall have been defined in Sri Lankan authorities by referring to both judicial determinations and legislations of the other jurisdictions. It is evident that the judicial determinations on construction of the phrase have mostly relied on key few Indian authorities and followed by the judicial precedents of the same scope of interpretation. And third one, there had been no adequate reference to scholarly works have employed by the Sri Lankan judiciary to unwrap this phrase, two phrases, either adultery or living in adultery, particularly to the maintenance claims. And next, the substantive legal argument could be emerged that the proof of living adultery under present statute shall be established beyond reasonable doubt as the maintenance claim tried in the magistrate courts. The standpoint of the Sri Lankan judiciary in this regard had not been firmly practiced the tool of establishment of living in adultery under the present statute as beyond reasonable doubt. However, it was illustrated by the Supreme Court in 1986 that the event of a question of the standard of proof, the magistrate shall take the yardstick of most favorable for either party to the conflict. Subsequently, the above perspective of burden of proof living in adultery under the statute shall be reinterpreted with applying the legal formula as explained by Justice Veeramantri in his work in 1975, proved by clear, strong and cogent evidence. And finally, it was evident that section 143 of the Evidence Ordinance of Sri Lanka, together with section 3 of the Maintenance Act, shall be applicable to establish living in adultery, which has to be read. No particular number of witnesses shall in any case to be required for the proof of any fact, as Justice Aluvihara explained in Attorney General's versus Nihal case. The use of the words in any case in 143 of the Evidence Ordinance, the legislation intended to apply the principle across the broad all cases and irrespective of the nature of the case. So that's the end of my presentation. I would acknowledge the support and the guidance provided me to develop this research paper to Honorable Justice Navas. Thank you.
Thank you very much for that thought-provoking presentation. I thought it was very you had a lot of legal literature, legal jurisprudence. I must say, I must use this word, your presentation was amazing. Especially for a legal practitioner, I've been in court for a long period of time. When you say maintenance, it's basically magistrate court work, but I have seen in and out the superior courts, even in the Court of Appeal. Sometimes in the Supreme Court also you get maintenance cases, they argue. And you also spoke about, which is very interesting, was the burden of proof, as well as the definition to adultery, which was very interesting, and the history that you spoke since 1889 up to that 37 of 1999. But I must say, even with 37 of 1999 still in force, we still have a lot of problems in court pertaining to maintain action. Thank you very much for that wonderful presentation. Thank you very much. So our third presentation is going to be, it's the third presentation. It's on combating, it's a very interesting topic, combating online child sexual exploitation and abuse in Sri Lanka towards a statutory response. Our presenter will be MRIK Bandaranayake. She currently works as an academic coordinator at the Open University of Sri Lanka. She has obtained her LLB degree from the University of Colombo, and she is presently reading for a LLM degree at this university. Her research interest lies in the fields of criminal law. It's going to be interesting for me, and human rights law as well as restitution law. The floor is open to you, Ms. Bandaranayake.
Good morning, everyone. Honorable Chairperson, distinguished panelists, presenters, and participants. I am MRIK Bandaranayake from the Department of Legal Studies of the Open University of Sri Lanka. So, the topic of my research is combating online child sexual exploitation and abuse in Sri Lanka towards a statutory response. The advancement of modern technology has brought many benefits, from improved communication to access to information at our fingertips. However, this rapid advancement of technology has negatively impacted the lives of the people, particularly children, regarding their physical and mental health, social skills, and safety. Online violence against children has been a contemporary global concern in the modern world. This has become such a concern due to their vulnerability because of their age and their limited understanding of risks and, of course, lack of adult supervision. Online violence against children can take various forms such as cyberbullying, cyber harassment, online sexual harassment, and yes, cyber stalking and online hate speech. However, in this particular presentation, I am going to focus on one aspect of online child sexual violence, which is online child violence, which is online child sexual exploitation and abuse. So, against this backdrop, my research problem is whether Sri Lanka has an adequate legal framework to combat online child sexual exploitation and abuse. So, these are my research objectives: to identify the definition and scope of the OCSEA, which is an acronym for Online Child Sexual Exploitation and Abuse, to review the domestic and international legal standards concerning the same, to analyze lacunas in domestic law on OCSEA, to propose recommendations to address the lacunas in domestic laws on OCSEA, which is online child sexual exploitation and abuse. So this is my methodology. It is a doctrinal study which was based on primary and secondary resources. I refer to several international legal instruments and 2 domestic statutes as primary resources, and as secondary resources I refer to textbooks, journal articles, and websites. So moving on to the results and discussion part of my presentation. First, I am going to talk about the scope and the definition of online child sexual exploitation and abuse. To understand this concept better, first we have to define it. So, child sexual abuse, as you can see in the screen, is the coercing or emphasizing of a child to engage in sexual activities regardless of their awareness or understanding of the situation. Child sexual exploitation is a manifestation of child sexual abuse that occurs when an individual or a group exploits an inherent power imbalance to coerce, manipulate, or deceive a child into engaging in sexual activities. Finally, online child sexual exploitation and abuse is using digital technologies and the internet to exploit and abuse children sexually. So, concerning the international legal standards on online child sexual exploitation and abuse, as you can see, I have analyzed several provisions of four international legal instruments concerning that offense: the Child Rights Convention, the Optional Protocol of Sale of Children, Child Pornography, and Prostitution, the Lankan Convention, which is also known as the Council of Europe Convention on Protection of Children Against Sexual Exploitation and Abuse, and of course the famous Budapest Convention on Cybercrimes. So as you can see from this slide, all of these legal instruments, they provide certain outlines and about the nature and scope of this offense, and of course they facilitate international cooperation to investigate and punish this heinous crime. As I mentioned earlier, this research focuses on two substantive laws of the domestic law of Sri Lanka on online child sexual exploitation and abuse. The first one is the Penal Code of Sri Lanka. As you can see, I have identified several sections of the Penal Code, which of course is the primary criminal statute in Sri Lanka, which addresses some aspects of this offense. As you can see, Section 360B addresses sexual exploitation of children. Section 286A addresses obscene publication, exhibition, and other stuff relating to children. Section 360A refers to procurement of children. And finally, Section 360C refers to trafficking of children and people. So what I wanted to emphasize is that, yes, these statutes, these provisions refers to sexual exploitation and abuse of children. But as you can see, they are more focused on the conventional or the physical type of sexual exploitation and abuse. None of them explicitly refers to the online sexual exploitation and abuse of children. Next, I'm moving on to the Computer Crimes Act. As you can see, this act, it does not per se refers to this particular offense that I'm talking about, but however, this act provides an overarching view of this offense, and of course, it facilitates to investigation and prosecution of procedures concerning this offense. Now I am going to talk about the critique of the domestic law. Concerning the international legal standards, I have to, my first focus is on domestication of international law. As we are well aware, Sri Lanka is a dualist country. So, unless we have an enabling statute, the International Legal Convention does not directly apply into our domestic legal systems. So yes, Sri Lanka has ratified the convention, the Child Rights Convention and the Optional Protocol, but we have not enacted any enabling legislation concerning those two conventions. Yes, we have the Children's Charter of 1992, but I would like to remind you that it is a persuasive authority. It is not a binding legal instrument. So I believe that Sri Lanka needs to enact enabling legislation for CRC and the Optional Protocol. And of course, the Lankan Convention is the main international legal instrument that focuses on this particular offense. However, since it's we have to keep in mind that it is a convention of the European Council. However, it is open to non-member states as well. So, I argue that Sri Lanka has to ratify the Lankan Convention due to the proliferation and magnitude of this offense inside Sri Lanka. And of course, Sri Lanka is the first South Asian country that has ratified the Budapest Convention. However, Sri Lanka had made 4 reservations under Article 9 of that particular convention. So, Sri Lanka does not need to criminalize realistic images of non-existent children. But as we all know, with the advancement of technology such as the artificial intelligence, we have to focus on such developments as well. So concerning the Penal Code of Sri Lanka, these are the main lacunas that I found. The Penal Code does not explicitly address the concept of exchange between a perpetrator and a child involving engagement in sexual activities. It also doesn't provide comprehensive coverage of the various forms of online child sexual exploitation and abuse. It also does not explicitly cover child sexual abuse material or child pornography, lacking clear definitions on certain elements. And of course, it does not address stimulated representations or realistic images depicting children, which is crucial given the advancement in the artificial intelligence technology. And also, the conviction rate under Section 360C, which is the Section on Trafficking of Children, remains remarkably inadequate. Concerning the Computer Crimes Act, this has several potentials. These sections substantively facilitate the investigation and prosecution procedures. However, as you can see from the slide, it is evident that this act does not include any a specific definition or any particular penalties or a dedicated focus on this particular offense. Therefore, I argue that even though there are two substantive statutes in Sri Lanka which addresses some particular aspects of OCSEA at different stages and levels, none of them are comprehensive on this offense. Accordingly, it is fair to conclude that the existing legislation in Sri Lanka, which are the Penal Code and the Computer Crimes Act, addresses certain aspects of the online child sexual exploitation and abuse. But I argue that they need to be more comprehensive in defining or addressing the multifaceted nature of this issue. Therefore, it is imperative to establish specific legislation that adequately addresses the evolving, transformative and dynamic nature of online child sexual exploitation and abuse. Thank you very much.
Thank you very much for that excellent presentation. I must say that it is very, very timely, especially with the IT law coming in with cross-border transactions as well. There have been a lot of crimes. I must say that you spoke about the international conventions as well as what is very important that you spoke about the local law, the amendments to the Penal Code Act and all those things. And what was very stimulating was you showed the lacuna, how the international law has not still come into the local law, to the domestic domain. And I must say that we still have a lot, even with the amendments to the penal code, especially with 22 of 95 and all the other amendments, we still have a lot of problem when the law is developing, when international transactions are moving forward. Your topic, I think it has given a lot of insight and a lot of wisdom to all of us. Thank you very much. Let me take this opportunity to introduce our next presenter. There are three presenters, three authors but one presenter. The topic is the prevention of domestic violence instigated by the INSEN, an analytical study on the Sri Lankan perspective. There will be one presenter, I believe, in more Ravindi, and the topic was developed by SL Silva as well as KTDS Silva. May I be permitted to introduce Ms. M.O. Ravindi, who is an undergraduate of Faculty of Law, the researcher John Kotharawa Defence University. Her research interest lies in the fields of law of persons, legal systems, as well as history and legal methods. SL Silva, the other author, is an undergraduate of Faculty of Law, General Sir John Kotharawa Defence University. His research interest lies in the fields of criminal law, evidence law, as well as procedure law. Ms. KTDS Silva is an undergraduate of Faculty of Kotharawa Defence University, Faculty of Law. Her research interest lies in the fields of law of persons, law of property, and legal methods. I take this opportunity to introduce Ms. M.O. Ravindi. The floor is yours.
Honorable Chair, Judges, distinguished guests and participants. A very good morning to you all. My name is Ravindi and my research topic is the prevention of domestic violence instigated by the INSEN, an analytical study on the Sri Lankan perspective. First of all, we will identify the research outline. Firstly, the introduction, then research problem and methodology. After that, facts and findings. It will discuss under four parts: global statistical data, Sri Lankan statistical data, Sri Lankan context and UK context. After that, discussion and finally the conclusion. So what is domestic violence? Simply, it could be defined as the physical and psychological impact of people living in an intimate relationship or family unit. Domestic violence can be defined as a huge problem in Sri Lanka as well, and it is a very much hidden problem. It must be noted that there are no boundaries to domestic violence, and the effect of domestic violence go beyond geographical boundaries. So, who are the main victim of domestic violence? Yes, the main victim of domestic violence will be women and children. And even sometimes men could be victim as well. Then what about insanity? Even though one of the main causes of this violent behavior is insanity, there aren't any provision about insane person in the Prevention of Domestic Violence Act number 34 of 2005, which is the main source of legislation when we talking about domestic violence. With this, we identified a preliminary problem, that is, the law on the insane person who instigates domestic violence. As we found out through our research, insanity is a mental disorder that can impair a person's judgment and behavior and can be a contributing factor of the domestic violence which has not properly grabbed through the act. To find answer to this lacuna, we used qualitative method of research along with black letter method. As for our main sources, we refer to the domestic violence and a few case laws. As secondary sources, we refer to books and articles. When we move to our facts and findings, the highest non-prevalence of violence against intimate partner occurs in Sub-Saharan African region and South Asian region. Further, it is identified that there is more prevalence of young females to be victim of domestic violence than adult women. And as previously mentioned, there is a highest risk of person become a victim of domestic violence by a person who suffers from the mental disorders for many reasons. For example, work stress, emotional exhaustion, and financial problems make a person's mental judgment weak and unstable. And when we look at Sri Lankan standpoint, the level of education and poverty can also be considered as the main issues to instigate violence. Moreover, with the COVID-19 pandemic, domestic violence increased further due to restriction of movement and other limitations. The ultimately affected women, girls and children who became victims of domestic violence severely. It must be understood that men were also victims of domestic violence. However, in many cases, the male figure of the family was instigator of this violence. So, why we don't hear about incident of domestic violence that much? Simply, I can point a single saying, "Athule gini pitata nodenna," which means not expressing matters within one house to outside the world. The cultural background of Sri Lanka shows that women are fearful to reveal domestic violence incident, ashamed to complain about their face difficulties and think it is harmful to the family cooperation. And then think revealing the truth will badly affect their children. As for the male, they always try to show their strength rather than weaknesses. So many men don't reveal about violence instigated on them. Under the United Kingdom context, we can find the Sentencing and Punishment of Offenders Act 2012, which provides a definition of domestic violence and various other provisions on it, namely the case laws of Jemshaw versus Hounslow London Borough Council and Local Authority versus DM are important case laws under British law. When we move to our discussion part, the harm of domestic violence toward the victim who suffer from the insanity will affect their mental condition as a long-term issue. From the defendant's viewpoint, the causes of domestic violence according to the insane person differ from the ordinary person. In criminal proceedings, if an insane person commits an offence, he could bring up the defence of insanity either to minimize or to be acquitted from allegation. Then what about domestic violence done by the insane person? This has not been answered through the Prevention of Domestic Violence Act. Domestic violence that occurs through the matrimonial relationship must also be provided with necessary provision to relieve a victim of an insane spouse. Furthermore, the causes of domestic violence depend on the psychological makeup of the abuser. So, this can be identified under the facts of underdeveloped personality, the domination of women by men, and sometimes a strong link with alcohol. Even though the abuser is not blameworthy for his mental incapacity, but he must be liable for instigating violent behavior against his spouse and children. For this purpose, the Prevention of Domestic Violence Act must arise with these emerged issues. So, as per the conclusion, we must remember that every person has the fundamental right to live free from cruel, inhuman treatment and domestic violence. And on the other hand, domestic violence can be defined as being subject to a brutal, torturous, inhuman assaults and psychological distress. However, the Prevention of Domestic Violence Act in Sri Lanka, which provides the basic legal framework for domestic violence, is silent in this regard. Therefore, we propose that special provisions be made for domestic violence committed by insane person. With this, I conclude my presentation. Thank you for your interest and attention.
Thank you very much for that excellent job. I appreciate your professionalism and the points that you have raised. He holds a Master's in Defence and Studies from University of Kalansooriya, Sri Lanka, as well as a Master's in Human Rights and Democratization from the University of Colombo, and holds a Diploma in Defence Management from Devi University, Indore, India. He is also an attorney at law, so you are highly qualified and we are expecting a good presentation from you. The floor is open to you, Colonel.
Thank you very much, sir. Mr. Shanaka Wijesinghe, President Council, respected panel of judges, ladies and gentlemen, good morning to you all. My research topic is the impact of parental alcoholism on children's rights. The children are the future of next generation and they will follow their parents, guardians as they grow under their custody and make their own choices as future leaders that shape the entire world order, including the behaviors of future generations. However, the situation has been changed due to detrimental repercussions towards the children's rights, resulting lifetime difficulties. With that, sequence of my presentation as shown on the screen. The study focused on effects of parental thinking on children in terms of psychological and physiological functioning in order to identify negative impacts that cause extreme social and burden conflict. A special consideration was given to children's rights such as right to life, right to shelter, right to have safe environment, right to know and cared by his parents, right to family life, right to survival, protection, development and participation. Research problem. Children have no idea whether their rights have been violated even when they are experiencing it. Subsequently, it may lead to personality disorders with negative behaviors and attitudes of children. On account of these reactions, these incidents where children have been victimized due to parental alcoholism have not been discussed adequately, or necessary actions did not materialize to mitigate the same in future. The objective of the paper. Overall objective of this paper is to find out whether parental alcoholism has an impact on children's rights. The other objectives are to identify children who suffer harms from parents' drinking, to identify increasing risk of various negative outcomes such as violence, family separation, teenage pregnancy, mental health problems, poor academic performance, underemployment, of becoming dependent on social welfare benefits from a young age. To analyze possible long-term adverse effects of parental drinking towards children's rights and solutions to overcome social issue to some extent. Research questions. Following are the research questions I have selected. How parental alcoholism has a direct association on children's rights. What are the short-term and long-term effects on parental alcoholism towards children's rights? Is it possible to minimize or overcome the social issue in association with existing law in the country? Methodology. This research was conducted as a mix of qualitative and quantitative study. Available statistics to analyze 4 independent variables in relation to dependent variable. Available reports and questionnaire are used to research instruments. Available observations and case studies were used in order to obtain information. Random sampling method has been used with permission of relevant authorities. Sample size was 39. Sample which is less than 30 and greater than 500 is most appropriate as per the rule. Conceptual framework. Conceptual framework I have been used as shown on screen. Basically, the human rights, and I have narrowed down into the Convention of Child Rights 1989, basically is the UN Convention, and the dependent variable, it is secondary data. So in that I have narrowed down only to these 2 parts, dependence, addiction and sexual harassment and teenage pregnancy. And the independent variables, alcohol related, I have selected 4 areas, that is family separation, discrimination, poor academic performance and mental and other health problems. The primary data I have selected from the specific police area I have selected, Lanka police station, and the specific Ravindi division I have selected within the police station, and I have derived my recommendations. The report, ladies and gentlemen, reported cases and related data I have analyzed. So the reported cases within 5 months, there were 122 cases, and Again, I have categorized that cases according to the following categories: children's cases, family fight, illicit affairs, leaving house and minor assault, and the result after analysis as shown on the screen. Again, that reported cases and related data, I have searched what are the reasons for addicted or the drinking alcohol by the persons. So I have received that there were three main reasons. That is, first one is addiction, and the second one is enjoyment, and the third one is escape from problems. So whatever the result I have received as shown on the screen. With that, I have derived following recommendations. Promote community-based services to help prevent child interaction. Conduct programs to promote health of a child. Implement activities with the assistance of schools to get parents involved in their children's education. Conduct job assistance programs. Enacting of laws and law enforcement. Improve the efficiency of effectiveness of preventive methods. Solve the problem of shortage in professional social workers. Make aware teachers who have regular contacts with children should also be more socially sensitive. Development of underdeveloped infrastructure. Provide access to information. And finally, build the cooperation between the institute protecting child rights. The study will be an eye-opener for many other researchers that is essential to support any holistic approach in future. Recommendation derived above could be improved with consistent studies in the same field and also incorporating convenient technical tools as appropriate to specific fields. With that, I have come to the end of my presentation. The references and the bibliography have been used as shown on the screen. Thank you.
Thank you very much, sir, for that. I must say that it was an impressive presentation, very engaging and illuminating. I like the way that you presented, especially with the statistics. I must say this is a now alcoholism is a common problem, especially in the upcoming states. It's we must see that how we should protect the children, not only the children. We spoke about the parents as well, and we must have some new legislation, especially for alcoholism, which is not enough legal domain. Thank you very much for the wonderful presentation. We just have a few minutes for questions and answers. If there are any questions, we just have a few minutes, especially for the students. Are there any questions? Because for myself, I think I was enriched today from legal victims and data and things like that. Do you have any questions? Any questions? You can ask any question. We just have about 2 minutes.
Will be to Ms. Oshani. So, your presentation was mainly about domestic violence. So, I would like to know why domestic violence has been increased during the period of COVID-19.
COVID-19 is, in that period, COVID-19 was a new disease and it is affected throughout the world. Developed countries also had a high death rate. People always live from fear about their life. To control this disease, government imposed restriction on movement, so they have to stay at home. So it makes them to result of that, they can't maintain their relationship properly, and mental stress, isolation, these situations increased because of especially mental stress and isolation. That's
Any other questions, please?
Good morning, sir. Good morning, sir. My question is from MRIK Munasinghe. The question is directed at the recommendations part of your slide. It was mentioned that social workers could be used as a possible tool to address the issue that you brought up in your presentation. How exactly could that shortage be addressed, and what impacts would it have positively in addressing these situations?
In Sri Lankan society, when we consider about the social works, there were two lectures. I see that the level of education about the job of social workers, they have not, I should say, not, they don't have proper knowledge about the job, but when we consider about, when we practice in the job, they have, most of the time, they have violated their basic ethics and code of conduct and professionalism. So, and the next thing is that basically I have discussed about the children. So then the children, the things always to be confidential, and it should not expose to the society without consent of the children as well as the parents. So the social workers, if they not done their job properly, the informations which not exposed to the society may be exposed, and it will continue to many years. Normally in Sri Lankan society, we all know that the bad things always remain 100 years or more than that, but the good things we just forget. Hope you get.
My question going to the first presenter, Ms. Kumarasinghe. So you mentioned in historical framework the father has potential rights to on the children's right. Why you said the father get preferential rights on child custody over the mother?
Thank you for the question. When we consider the ancient time, we know that father is considered as the provider of the family, and while the mother is the one who takes care of the family. And another reason is that even when it comes to property also, property goes from father to son. So the legal rights of the father compared to mother is superior. So, and all these things related to the concept of patriarchy, which we already know, which is rooted in the ancient society. Because of this reason, why father got more supreme rights over mother. I think I already answered your question.
Thank you very much. Everybody, in conclusion, I must say, first of all, thank the organizers for selecting these topics. Well, the topics were very timely. So very timely. And the presenters, I must say, all of you are presented in a way that all of us could understand. Especially, I'm grateful for all of you all for the discussions and all the contributions made. I want to compliment each and every one of you for the speeches that you have made. My earnest hope is that someday that we could put all the theories that you have said into practical use. I think we are going on at this forum, personally for me, we are all very much enriched. A lot of jurisprudence, a lot of legal jargon, and it was excellent discussion. Thank you very much. Thank you so much.
We would now like to award certificates to the presenters of the session, and I respectfully invite the Chair, President's Counsel Shanaka Wijesinghe, to do the honors. I kindly request all the paper presenters to come forward and accept the certificate.